Welcome to today's podcast on key provision of Digital Personal Data Protection Act 2023, where we'll deep dive in one of the most transformative pieces of legislation of India's digital journey. In the world where data is currency and privacy is power, this act marks a pivotal shift in how personal data is collected, processed, and protected. Whether you are a tech entrepreneur, a legal professional, or just a curious citizen, understanding the law is essential. We will explore the right it grants to individuals, the responsibilities it imposes to the organizations, and the penalties for those who fail to comply. For cross-border data transfers to protection for children's, this Act India answers to the global privacy standards. A quick disclaimer: this podcast is for informational purpose only and does not constitute legal advice. The Government of India has a vision of Digital India and is headed towards the global goal of Internet for all. The Internet subscribers base has grown exponentially since 2024, from 2,050 million subscribers to over 850 million subscribers. The Government of India has also initiated the Digital India, a flagship program with a vision to transfer India into a digital empowered society and knowledge economy. The widespread adoption of digital technology has resulted in data privacy emerging as a critical concern globally. India is no exception, as the increased use of digital technology and consequent rise in the quality of personal data being generated has heightened the concerns about the data privacy in the country. India identified the most largest population of internet users in the world, and as a result, the personal data has been generated at an unpredicted rate. As the volume of personal data increases, so does the threat of data breaches and cyber attacks. The Indian government has recognized the importance of data privacy and has taken steps to protect personal data. Protecting of personal data is not only a legal requirement but also an ethical responsibility for individuals, organizations, and government. So, how the evolution of data privacy law in India has we have seen in couple of years from 2020 2000. In 2000, we had Information Technology Act, which provides basic framework for electronic transactions, cybercrime, and electronic records. It was further amended in 2008 to add Section 43A for reasonable security practices. 2011, there was a sensitive personal data or information rule under the IT Act, which amended the Section 43A again. 2017, from 2017, the right to privacy as a fundamental right was a judgment given. It recognizes the right of privacy as a part of Article 21. Since then, there were multiple bills that came in, but in 2023, the Digital Personal Act was passed in Parliament. The Why was the reason for this act? Because we have seen lot many data breaches and regulatory gaps since 2000 when the IT Act came in. So before the Digital Data Privacy Act, India data protected framework was fragmented and primarily governed by IT Act and sectorial regulations bodies like RBI, IRDA, and SEBI. While this provides basic security obligations and address sensitive personal data, they lacked a comprehensive global interoperability. There was no dedicated authority, limited enforcement capability, and inconsistent coverage across sector. The 2010 and early 2020 saw significant growth in the data-driven services like e-commerce, fintech, health tech, social media, etc. And there was number of cyber attacks incidents that has happened. Uh, the major are Aadhaar leak, over 130 million Aadhaar number reportedly exposed from government portal. 2020 big basket data breach. 2021 Air India passengers, where over 4.5 million passenger records were compromised, including passport, credit card details, etc. 2022 Dominance India, around 180 million orders details exposed on the dark web. So, what were the specific regulatory gaps that were identified? Comprehensive data protection law, absence of dedicated regulator, weak breach notification framework, limited individual rights, sectorial fragmentation, cross-border data vulnerabilities. So no, there was no clear rules on data transfer outside India, how we are going to enforce rights to access, correct, and erase the personal data, no mandatory requirements to report breach. So there was no specific laws that was there, and that's the reason there were huge gaps in the data, in the regulations that was there. But with each breach, there is a cost. Data breaches are more expensive because it will cost the volume and sensitivity of personal data compromise, time to detect and contain the incident, legal and regulatory penalties, loss of customer trust. So there are multiple industry studies by IBM for cost of breach certain data. Average cost for data breach in India was in 2023 was around 17 to 20 crore. Average time identified to contain a breach is around 280 days, whereas the percentage of breach involving personal data was over 80%. DPDP Act applies to the processing of digital personal data, whether done in India or outside India. So if the organization processes any digital personal data in India, you are in the scope. Public entities, private entities, individuals, business professionals, etc., you will be in scope. Even overseas businesses targeted Indian customers must comply to the DPDP Act. So if you are offering goods or services to the data principal or individuals in India, or you are profiling the individuals in India, you are in scope for that, and you have to comply with the DPDP Act. There are some exclusions, like if you are having a handwritten visitor logbook, manual data processing without digitalization, data used for personal and non-commercial purpose, like person contact details, data made publicly by the data principal. Those records are exempted from the DPDP Act. The DPDP Act clearly identifies four primary roles in the personal data ecosystem: data principal, data fiduciary, data processor, and significant data fiduciary. Uh, Data principal, let's go one by one on which are these roles. So data principal, the individual to whom the data personal data relates, the individual, the bank customers, the e-commerce site registered users, anybody. So what are the rights is access the personal data, request, they can request correction or deletion, withdraw consent, appoint a nominee in case of incapacity of death. Data fiduciary, any person, company, government bodies or entities that determines the purpose and means processing the personal data. Example, any hospital managing the patient records, any fintech company collecting the KYC data. This comes under data fiduciary. Data processor, any entity processing personal data on behalf of data fiduciary and under its instructions. So any cloud service provider hosting customer data, these are the examples. Any outsourced call center handling support requests, these are the examples for data processors. Significant data fiduciary is classified by central government based, so large social media platforms, national level health insurance databases operators, etc. comes under significant data fiduciary. These are ruled by some 5 core principles: lawfulness, purpose limitations, data minimization, accuracy and security, storage limitations. So what do you mean by lawfulness? Process personal data only if it is a valid legal ground, either consent or other lawful basis under the act. The example is hospital collecting patient information under consent and for treatment and for statutory health reporting obligations. Explicit consent from the data principle is important. Compliance with law or court order is important. Purpose limitations. Use personal data only for the purpose specified at a type of collection. So when we are collecting the data from the data principle, the purpose we have mentioned, the data is to use only for that purpose. Example is e-commerce site collecting phone numbers for delivery updates and cannot be used for marketing without additional consent. Data minimization. What do you mean by data minimization? Collect and process only the minimum personal necessary data to achieve the state purpose. Example here, ride hailing app collecting location data only during the ride and not storing it. Accuracy and security. Ensure personal data is accurate, complete, and up to date, and implement reasonably security safeguarded, like encryptions, access control, secure networks. Apply at least privilege access principle. A bank updates customer address upon request and encrypts data account data in its databases. Storage limitations. Retain personal data only for as long as necessary for the stated purpose or as required by the law. So define the data retention period should be defined in the policy. Automated deletions after expiry should be put up. Employee data should the employer deletes former employee access credentials immediately after separation. That is example for storage limitations. Coming to the rights of data principle. So data principle have the rights to know what personal data is being processed, the purpose for which the data is processed, and the entities with whom the data is shared. Example, a customer requests a telecom provider to share all personal data and usage history stored in the system. Right to correction and erasure. So data principle can correct inaccurate and update outdated data, delete personal data, withdraw the consent once the purpose is fulfilled, retention is no longer legally required, right to grievance and redressal. So unlawful processing, breach of the right, failure of fiduciary to respond to the request. So data principal can file complaint for this. Right to nomination. Data principal can nominate another person to exercise their rights in case the death or incapability. Example, social media user nominate a family member to manage the account in case of death. So as there is our obligations on data fiduciary, similarly there are some duties of data principal also, that they should ensure that the data is truthful, correct and complete. Data principal should not file malicious or false complaint against the data fiduciary. Also they respect other laws, applicable laws that are there. What are the so DPDP Act imposes specific responsibilities for data fiduciaries who are collecting the data to ensure lawful, secure and transparent process for personal data. So the consent has to be taken, consent must be free, informed, specific, unambiguous and given through an affirmative action. They have to implement reasonable technique to safeguard the data, to make sure if there is any data breach, they have to inform the Data Protection Board of India in a timely manner. The The DPO must be based in India, responsible for compliance monitoring, regular independent audits to verify compliances with the Act. DIP required to process involve high risk and individual privacy over there. What are the duties for data processor? Data processor must process personal data strictly under the instructions of data fiduciary, implement appropriate technical and organizational measures to protect the data, like encryption, access control, regular security audits, support data fiduciary fulfilling obligations like responding to data principal rights and breach notification, provide timely access logs, breach impacts, etc. Cooperate with data fiduciary for in conducting data protection impact assessment for audits. Data processor must not determine the purpose or means for processing. Avoid collecting of and using data beyond any contractual scope. Data Protection Board of India is a statutory independent body established under DPDP Act to enforce compliance, ensure efficient grievances redressal. Its digital first operation enables faster investigation and decisions. Key functions of DPPI, that's Data Protection Board of India. So they should be handling the complaints, receiving complaints from data principal regarding any right violations, unlawful data processes, examines report or discovered data breaches or cause and impact, order corrective actions, security enhancements or operational changes to prevent reoccurrence, issue guidelines and best practices for reducing future privacy risk. Uh, if there is a data breach, the DPDP Act mandates the data fiduciary and data processor responds promptly and effectively on data breaches. There are some permitted grounds on which data can be collected without the consent. As for certain lawful grounds where data can be imposed without consent, some of the exceptions are like data can be processed to perform government functions to deliver benefits, services authorization by law, like processing citizen Aadhaar card to distribute the government subsidies, processing required to comply with law, regulation, courts, orders, or legal proceeding. Uh, Simple example can be a company submitting employee tax details to income tax departments as per statutory requirement. Employment purpose, processing necessary data for recruitment, performance review, payrolls, disciplinary action. So the organization stores employees' data, account, bank account, salary details, etc. So those are for the purpose. Similarly, in medical emergencies, share patient records with the hospital during the accident, or law enforcement request telecom for record for investigation of cyber crimes. This can be some of the examples where the consent is not required. Similarly, DPDP Act permits transfer of personal data under regulated countries. Transfer are non-automatically open. They are subject to government notification and can be restricted for national security or public order concerns to ensure data sovereignty while enabling global business operations. Special provision for children. So DPDP Act provides enhanced privacy protection for minors, individuals under 18 years of age, recognizing that children require greater safeguarding in digital environment. This provision aims to prevent exploitation, protect online safety, and ensure responsible data processing. So for children below 18 age, consent from the parent is required. Parental consents are mandatory. Uh, they should not be tracking or profiling the kids' behavior or any activities that are done by the kids. So there are a lot many regulations or rules we have seen. If we don't follow that, then what? So DPDP Act has enforced strict financial penalties for violation to ensure accountability and deterrence. Penalties are determined by Data Protection Board of India based on the factor like severity, duration, impact, and extent of harm caused. So what are the penalties? So major penalties, the Data Protection Board has a power to issue penalties up to 250 crore. The data fiduciary are liable to pay penalty of 250 crore for the breach in observing for obligations of data and take reasonable security safeguard to prevent the personal data breach. So penalty for data breach is observed, misuse of any data principle, breach in observing the obligations to give the board or affect data primary notices around 200 crore. If the breach is observed for additional obligations of significant data fiduciary non-fulfillment of duties 150 crore and failure to address grievances 50 crore. These are some of the penalties that needs are there or the board can put in. So this is what we have understood the rules and penalties, but what are the way forward? How the organization should go, what they should be doing. So initially the step-by-step methodology that the organization should follow is conduct a data mapping and gap assessment. So whatever data is collecting, there has to be data mapping to understand what can be shared, what cannot be shared, what for what data, what controls needs to be implemented. They should draft a privacy policy and notice templates. There has to be clear privacy, has to be updated on how the data will be used, how it will be stored, what are things will be there. Deploy a system to track, manage, and withdraw user consents. Provide platform for data principals to file grievances and exercise their right. For significant data fiduciaries, designated a data protection officer and implement a cross-function governance framework. Regular training and sensitized program to embed a privacy culture. Develop a breach response protocol, conduct simulations and ensure readiness. Review and revise vendor contracts to include DPDP, aligned privacy and breach terms. Conduct internal audit and data protection impact assessment, especially for high risk processing. And review cross-border data transfer mechanism. These are some of the pointers the organization should take care. So as you've seen that DPDP Act is a landmark step in Indian digital regulatory revolution. While challenges in implementation remains, a risk-based and proactive approach for our organization can ensure compliance, build trust with customers, and avoid regulatory reputation risk. Thank you. Thanks a lot.